Hey everyone, this is the India story, which, as you know, has been really looking at reforms and driving forward the India story and how can we move and improve the country in a faster pace. Now, many people believe that the crux of the matter and one of the most important things that needs to be fixed is the legal and the judicial system. How can that be done? There can be nobody better to talk to us about that than Justice Sanjay Kishan Kaul, who is a retired judge of the Supreme Court, one of the biggest advocates, I would say, of judicial reform, legal reform, who's given a lot of thought as to how the legal system can actually work better. Justice Kaul, it's such a pleasure to have you with us.
Thank you for having me over.
It's a privilege. We are actually going to get you to do for the next 40, 45 minutes sort of open-ended brainstorming with us on how we can actually fix the legal and the judicial system. How do we get it to work better and in a more efficient manner? But before I do that, would you agree that there is a problem and a problem that needs to be fixed?
Absolutely. I don't think anybody would dispute that we have a problem at hand. We have a large problem at hand. There may be difference of perceptions on how to fix it. But I think the most important thing is to first identify the problem and proceed by whatever method you want to. There cannot be a status quo to the situation we have at present.
Would you agree, Justice Kaul, that the delays in the legal system, the time it takes to bring matters to trial, the pendency of matters, would you think this is one of the biggest problems that the country is facing today?
Well, it is certainly the biggest problem the judiciary faces. And the judiciary in India has a very important role. It's a multifaceted role because it is what I believe the check and balance on any government, whether at central level or state level. There is also a question of certainty which must arise when people go to court and would like to get their rights determined for or against them, whatever the results, in a time-bound manner. I believe that in an age of technology where everything is instant, to expect people to wait for decades together at least for their individual grievances is something which is completely unacceptable.
Justice Kaul, one of the reasons that we on the India Story podcast keep coming back to the question of legal and judicial reforms is that for the average citizen, let's set aside what happens to the corporates or to the government who are big litigants. For the average citizen who sometimes is also caught up in matters of personal liberty or is dealing with matters of their livelihood or their land, the fact that they cannot get justice for 5 years or 10 years or 15 years is something that potentially puts a very major burden on their lives.
Yes, I would agree. But, this problem is arising also because the executive remedies and other remedies which should operate and the matter should not come to court are not operating. So what happens is everything comes onto the court. If no decision is taken, they'll say you go to court and get your remedy. I still believe, despite all its problems, people have faith in the judiciary. That's why they come. But the time period which is being taken is too long. And there is no single solution to this. I think it requires a multi-pronged attack on different areas if we have to tackle this issue.
And I'm going to take you through many of those multi-pronged areas that come up. The other aspect, because let's just finish outlining why this is such a serious problem. The other issue that many people say is that in a situation where it takes 5, 10, 15, 20 years, maybe 30 years to get a decision and to get justice, that's not justice, because if you're a guilty person, that delay is good for you. If you're an innocent person, then that delay is bad for you. So the present system of delayed justice is justice denied, and more specifically, it's good for somebody who's guilty and is bad for somebody who's innocent.
So I will look at it two angles. One, you are right. I used to call it pay to litigate. So it pays to litigate for a person who I would perceive not on the right side because he thinks it takes too much of time. But on the other hand, we also don't count there are many cases which are of the moment, say a corporation, a public body, which do get decided within time. Those don't invite much attention because they are decided in time. The ones which are not decided take time. And we have to categorize ultimately which are these cases which are creating this backlog. there is no one say for different courts. This problem will vary from high courts to high courts. It varies from the nature of litigation from high court to high court. So there is not one end solution to all which is required. I've had experiences at least of 3 high courts where I have been. And the subject matters which are clogged down also vary at times. But there is a line which runs through them where one would say at least certain category of cases are the one which are backlogged.
Justice Kaul, if I had to ask you, and I'm going to now take you through the details, both in terms of what you've said in the past, some of the judgments that you've done, but I would like you to start spelling out for us some sort of a blueprint. If you were given a clean sheet of paper and said, Justice Kaul, you've been at every level of the judiciary, help us unclog this system, what would be the contours of a solution according to you?
So, to my mind, one of the important issues is the management of the court itself. We have to learn to manage our courts better, the administration better, the timelines better. See, we don't have an ideal situation where lawyers can argue at length and we can continue to listen. Times were different maybe a couple of decades back. So, each of these issues require to be attended. I do believe that maybe some outside agency experts and management are today required to be broached with the assistance of the particular problems of the judiciary to see how better we can manage the systems. Let's take an example. Courts are overburdened, there is no doubt about it. Judges are overburdened, there is no doubt about it. But then if a date is given and that keeps on rolling over, it results in frustration. So you may be able to give a long date, but on that date, if the work is taken up, I have a belief that people will accept it. But when it keeps on rolling over, that's the problem which arises, which is a management issue. So some judges, I think, are better at managing their own courts, some not so. So it should be an institutional issue. It should not be an individual judge-based issue, where somebody has to decide which are the cases which are creating a backlog, what is the line which must be taken in those cases, and how the time frame should be fixed. I believe when limitation of oral arguments is necessity of the day. You give a brief synopsis and get it done with. We are also burdened with a lot of case law. Every year the SEC online will throw out 20 volumes of judgments of the Supreme Court alone. So the precedent is creating a lot of problem. If we look to, say, the method of arguments, the method of presentation, and method of writing judgments, all 3 require attendance. Lawyers will have to learn to write more briefly, argue more briefly, and the judicial fraternity will also have to learn to write briefer judgments, because we are not here as academicians to create a thesis. We are here to decide the list of the party, and in a simple way which that litigant understands what we are deciding. Now, to do all this also, we require adequate number of judges. You can't have a judge population ratio of 20 to a million as against the US of 150 to a million. It was supposed to increase slowly to about 50. Forget that, the existing vacancies don't get filled up. So we have today a scenario where district court vacancies exist. High courts about at least 70% strength is working strength. So how do we talk about increase of strength and having more judges to deal with more matters unless we fill the vacancies which exist? So this is one of the major issues.
Justice Kaul, I think what we just heard from you was almost like a sort of a mini blueprint on what you call the management of the court, and what in popular parlance is sometimes called doing away with the tariq pe tariq, system, which is that you keep having if you go to a court, there are 40 matters or 50 matters or 70 matters listed, 10, 15, 20, 30 of them will be listed, the rest of them will roll over. So somebody who is there is paying an expensive lawyer, the lawyer is showing up, and the matter just keeps getting adjourned time and again and again and again. That's what you mean by fixing when it comes to management of the court. And you said that the first thing to do is fix a date and actually hear the matter on that date. Can that be done? That you just say your matter will come up. Maybe it's a long date. It'll be heard in November. But on the 15th of November at 11 a.m., your matter will be heard, we guarantee you, and it will not be adjourned.
So it can be done. but that will require as many matters before the court as the court can take up. A lot of time is wasted in the court merely by trying to get an earlier date, in giving dates to a matter which will never be taken up, because you know a judge can't decide 60 cases in a day at a high court level. So that structuring is necessary. You are right. What is required is that on the date it is to come up, it should be taken up. That can only be if the roster of the judge is structured in a way where his listing before the court is taken up on that date. So there are courts, I know in Singapore, for example, where they give you slots of time. So people just don't keep wasting their time. They will structure it and say, okay, 10 to 12, these many cases are expected to be taken up. Remaining time, some other cases will be taken up. For a rare reason, if it is not taken up, a date will be given, but that lawyer and litigant will not keep on waiting. This is just an example of it. Writing judgments within time is becoming a challenge. So there are courts where you hear matters and then there's a break to write judgments. See, a lot of time we get criticized as judges that you have holidays, you have so much of time at hand. Well, the normal working time of 4.5, 5 hours in court requires at least 5 hours plus to be able to read and do justice to what you're going to hear in court. Otherwise, you can't deal with these volumes. If you have a limited number of cases, you can tackle them judicially and therefore produce results. Now, if unless we are able to structure it in this manner, well, some judges say, look, if we give dates very long time, say November, those lawyers raise an issue. My own experience is if the lawyer knows that on the date when it is given, whether it's 6 months down the line, 8 months down the line, it will be heard. It will be better than to keep on rolling over matters. Our job as judges, I don't think, is to please the lawyers by giving shorter dates when dates will not be taken up. It's frustrating and it is also expensive.
I may add that for the clients, it's better to have one date, so you're paying the lawyer once rather than having to pay the lawyer 4 times because the matter is getting rolled over. Now, to achieve what you are suggesting, and I think everyone would agree that's the right way to do things, yes, you're right that on a particular date, a smaller number of matters has to be listed before a judge. Otherwise, there's no chance that he could possibly take up 50, 60 matters. But it could also be important to have a time limit, that to say you give written arguments which are 2 pages or 3 pages, I think you used to insist on 3 pages, and then say you can argue for half an hour, no more. That's it.
Yes, I think, as I said, its time has come for pleadings to be precise and brief, arguments to be brief, and synopsis to be brief, and judgments to be brief. Because that's the only way we'll be able to get the output which is necessary. We are in a crisis situation, so let's not look at a utopia. We should be able to do things in a particular time frame and try to clear the backlogs which is there. Of course, one of the issues is that, well, if the listing takes too long, then also their lawyers feel aggrieved. Well, say a Delhi High Court, the listing occurs the next day if it is filed by 12 o'clock. But the judges complain that the volumes are so large of the supplementary, what they call. The supplementary is the fresh cases which come up. They are left handling most of the day those fresh cases. Plus, with so many other these cases, to be able to read, come and tackle them within time also becomes a challenge. Therefore, I said multifaceted issues are involved. And I think one of the biggest problem is that if you look to other countries, government, I seldom think will be such a large litigant anywhere. In India, 60% almost of litigation is by the government. In terms of things being filed in time, most difficult to get out of it. In terms of continuing appeals after appeals till the last court, again a system, because nobody wants to take a decision which case is worth carrying further or not carrying further. They're apprehensive of the consequences which would arise in this. So we have to develop also some system, or the government should develop some system where they take some kind of a little away independent body takes a decision as to how many tiers to the case should go through. To my mind, for any litigation, 2 independent judicial tiers should be enough. Good, bad or indifferent, the case should rest at that. 90% of our litigation is routine litigation, which can be rested with this.
So I think you've raised this. I'll put this down as point number 2. So one was effective management of the court system. Number 2, reducing the amount of government litigation. And you're right. 60% of the cases right now that are there in the court system, we talk about pendency, but 60% of those cases are from the government. And I think you're also correct in saying that what happens is, for an individual government officer or somebody in government, it's safer to say, let the court decide rather than me deciding. Because if I decide, tomorrow there could be a vigilance inquiry or somebody could come and ask me, "Kyun tumne aisa kiya?" If the court has decided, then there's no risk to me. Is that a genuine problem, you feel?
Absolutely. See, I have had discussions post-retirement with law officers also. They said even if we opine in a case that this should be end of the matter, they'll go to another law officer and take an opinion and say, well, I want to fight it. Because they want the seal of approval of the court so that tomorrow if somebody raises an issue, it can be said, what can we do? The court did it. So that's the problem. Otherwise, if you look at the Supreme Court, see, one of the largest areas of litigation is service matters. What is service matters? Dispute between public sectors or government and their employees. Should the Supreme Court be clogged with that? Next, the number of tax matters. Nobody assists how many of them are going to succeed or not succeed. Most of them deal with certain aspects only. Every case is taken up. Of course, the tax department has said this now, that if it's a valuation issue below a certain valuation, we will not go. But that's not the only solution. Criminal matters, these three clog the system. Apart from that, there are special statutes from which appeals lie to the Supreme Court. So the apex court is burdened with appeals directly from them. All this burdens the Supreme Court because the filing increases. And the unfortunate filing issue which is arising is bail matters carrying from the lowest court to the highest court and argued ad nauseum like a trial and a matter.
I'll come to bail in a couple of minutes because I think that's another major issue and something on which you have written and extensively. But I'm trying to figure out how to change the incentives to make sure that for a government officer, it is not the simplest way to clear files off the desk by saying, let the court decide. Or for that matter, if there's a matter that has been decided by a district court or a lower court, to say, let's just appeal. Why take a chance? Appeal karenge, let the higher court decide. There has to be a way of shifting the incentives. We just heard Justice Nagaratan, for example, actually coming down and imposing costs on a government department, saying, why did you appeal in this matter when it was so clear-cut that you didn't have to appeal? If you're worrying about pendency, why are you keeping on appealing? Is that the answer, that costs are imposed, or what else can be done to change the incentives?
So I feel one of the issues is you must have, away from the direct line of decision-making, a independent panel, which I said, maybe of 2 or 3 people, a technical member, a government member, and a retired judge, who will take a call as to whether to carry the matter forward or not. So that the person in the direct line knows that he is backed by this rather than by a court decision. Costs, yes, are important. I have believed also that in this day and age, the age-old principle that the government works slowly, so you should be very liberal with the government in limitations while coming to the court is not something which has ever appealed to me. I have dismissed including tax appeals on grounds of limitation, saying you can't come after 200 days, 300 days. If such an important case is there and you've not come up, what action do you take against your officers who do so? So if you're talking about that some officer is mixed up, then you must take action against the officer. And if you're just coming in a routine to get a certificate from the court, then the court should not be the certificate-giving authority for litigation purposes. I believe cost is an important issue in every field. I think normal tendency in most courts of the world is that the losing party pays cost. Here we take it, the lawyer often takes it as an affront that you are imposing cost, means is there something wrong I have done? No. You've lost a case, so your litigant must bear the consequences of losing the case. That itself is a disincentive to keep on appealing further, whether it's a private party or a government party.
But what you just suggested, I think, is an excellent idea. If what you're saying that within every government ministry or government department, there could be a litigation department, or I think you've suggested this also in many times publicly. If there's a litigation policy where departments say that these are the people who are empowered to take a look at matters and say, please don't go to the court about this, it's a losing matter, or they say, don't appeal further, it's a losing matter. Bring finality to these matters. Then that gives you that slight certificate aspect that you're asking for. two sets of minds have looked at it, but it's happening within a department rather than creating a new case which is going to linger for 10 years.
Yes, that's what I feel, that there has to be, after all, that officer is looking to cover his back, frankly. So if instead of going to the court and getting it dismissed, he can cover his back by an independent body which is created institutionally to look into it, it would, I think, subserve the purpose to a larger extent, if it is followed.
If it is followed. So is that something which you think is a low-hanging fruit that we should push for?
Yes, I think so. You know, in some cases I found even there are conciliation committees within the system. Even where conciliation committees have opined in favor of a private party, these are contractual matters, which now I deal with post-retirement. Despite that, the public bodies at time go into litigation. So there should be some policy that once this is done, it should be the end of the matter. And you can't keep poking and finding out what is happening and why is it happening. You must have trust in the people you appoint to do this task. And then it must rest at it. There is no perfect solution to it. There will always be two opinions. It's always said Supreme Court is final because that's the last court. If there's another court above it, I think even many matters of Supreme Court, a different view could be taken. So there should be an end to numbers of tiers of scrutiny. To my mind, one of the most important aspects is, apart from checking the number of unnecessary appeals, is fix how many cases a case should travel through how many tiers of scrutiny. As I said, 2 independent judicial scrutiny should suffice.
And then after that, there's finality to the matter,
Yes,
because then
you have to accept it. Let me put it this way.
you have to accept it if you lost it. That's so. Let's hope some of this gets done. But that brings us to another aspect of it. If you are saying the crux of the matter is reducing the number of cases that there are right now, if 60% of the cases are from the government in some form or the other, is it time for a one-time scheme, or maybe every 5 years a scheme is like that is brought, where let's say the Prime Minister's office or some direction comes from saying that all government departments across the country, please take a look at all the cases that you have. Find the weakest 30-40% of cases. Bring them to a committee and saying, we think these cases are weak, right? But we don't want to withdraw it because why should I take the risk of withdrawing it? You take these 30-40% of cases, bring it to a committee and saying, we don't think this is going to go anywhere. One time, drop 40% of cases. That automatically brings down your pendency by 30 to 40% in the country. It will completely unshackle the entire legal system.
See, also, apart from what you are saying, it gives confidence that the remaining cases are capable of being tackled.
Exactly.
Once you weed out. So weeding out of semi-deadwood or deadwood is also an important part. And this varies from court to court. So I'll give you an illustration. Say in Punjab, Haryana, a long time back when I was Chief Justice, we looked at the subordinate courts. More than 5 years cases were about 3%, not more than that. If you see the same thing in Tamil Nadu where I went, similar number of judges' strength, similar number of filing, but the old cases were almost 25%. So you realize there was a different problem here, maybe arising from adjacent districts and the criminal cases. All of us, including myself, collectively, we said, okay, let's try to, if it can be 3% there, let's try to do something here. In 2.5 years, we brought it down from 25% to under 18%. So you have to concentrate on these old cases. In a judge's time in a day, I do believe it must be allocated for different subjects, time-wise. So there is a subject which is the fresh cases, there is a subject which is coming over after rollover, and there are the old final hearing cases. I believe every day the board must move to some extent in all three categories, so that people waiting for years together don't get a feeling that their cases will not even be listed.
But the one-time dropping of all these old matters and weak matters and frivolous matters, which I'm sure are cluttering up the system right now, when the principle of Jan Vishwas and others is very correct that we should not have these frivolous matters coming up in the future. They're largely rent-seeking exercises. But is there time for a one-time cleanup of the entire backlog?
Yes, I do feel that we have to bite the bullet and take this decision. I'm given to understand by one of my colleagues still in the Supreme Court that on the criminal side, some experiment is in place in Tamil Nadu, where many criminal appeals were pending before the High Court. Now, a lot of these appeals are for less than the heinous cases. So it's 7 years and below. Now, if a person is, say, served 3 years, 2.5, 3 years out of it, as a measure, not as a one-time measure, as you say, some methodology where the state government or the central government brings these cases to an end. My own view is that if the so serious cases are got out of the system, the judge will have time to try the more serious cases which are there. So it will give him more time to handle what then gets neglected and results in acquittals, and then the grievance says, oh, the courts on the criminal side are acquitting everybody. Somebody must have done the task. Yes, of course, somebody's done the crime. But then you can't punish it on the basis that I think somebody's done the crime. It'll have to weigh on the basis of evidence. So there has to be scientific investigation. There has to be proper prosecution mechanism for it. And that prosecution mechanism gets spread over a large number of cases, while it should be concentrated in the smaller, more heinous number of cases.
So, as you said, if the management of the court is happening correctly, which is number one, government reduces the amount of litigation. And number three, I think, is if there's a one-time sort of a cleaning up system, then again, that is something that will help. Do you think it is also important to focus a little bit on the sort of law, on the process of limitations, right? Like you were mentioning tax, there is a reasonably robust system of limitations that has come in there. So a lot of old cases just don't come up anymore. In other cases, limitation can linger forever. Like investigations can be open-ended. Some FIRs can remain open forever, and you can before offense could have happened. It could be 20 years before an FIR is filed. Do you think we need to have a tighter time limits which are enforced very rigidly?
So I think time limits are there, but the enforcement mechanism has become such that we are not looking to ultimate convictions. We are looking to the process becoming a punishment. Now that cannot be the solution. You can't say because you want to keep somebody behind bars and you think he's done it, whether we get his conviction or not, let us keep him behind bar as an under trial for 3, 4, 5 years. That becomes his punishment. So there has to be a system to see that things happen within a time. Now that requires today a more scientific investigation itself. I know in economic offences at times the challenges become harder. The challenge becomes harder because the technology available. But then the prosecution must also have that technology to be able to handle it. And that's where you need an upgradation of the skills. I remember in Delhi at one stage when I was sitting with the Chief Justice, we said on a very simple scale that law and order and prosecution in cases should be segregated. So investigation and law and order should be segregated. We did it in some of the police stations. Skill set is very different required. The thing starts from there. Is the policeman trained to do investigation, or is he a law and order man just put there to do investigation? So baby steps at base level are also required simultaneously if we want to tackle these issues.
Yeah, I mean, you mentioned, so for example, in 74, there was a law that was enacted saying that economic offences should not have a statute of limitations at all. It can be in perpetuity. But perhaps it's time to look at some of those. Like, should you have 30 years as a limitation, 20 years, 10 years, 5 years, something?
There has to be a time frame for everything. If you can't, in today's day of technology, detect things within a reasonable period of time, then you must bear the consequences of your negligence, is how I would say, especially as a short-term measure. Therefore, we'll have to take a short-term view and a long-term view. In a short term, to have better results in a long-term view, we must make sure that we get rid of these cases, even by imperfect methods, for some time, to see that we can concentrate on the more difficult cases and do so. After all, a very base example of tax violation. After all, the government comes up with these tax schemes every 8 years, 10 years, they come up, they waive off things. Why do they do that? They want to ensure better compliances. Similarly, in the court system, there should be an ability to have better compliances by administrative cooperation also.
So that's an interesting thing, that think of some one-time schemes to clean up the system and focus on the important areas. So if you move to the important areas, one of the matters that everybody would agree, and you in particular, I think, have been a very strong proponent of that throughout your career, is the importance of personal liberty and therefore the codification of what is happening in things like bail. What is bail? Should it be bail, not jail? How should that be done? And as you correctly were saying a short while back, a lot of time is spent in discussing this, including at the Supreme Court level, whereas perhaps it could be codified, and you did try to codify it.
So, while dealing with one of the matters, in Antil's case, in fact, I asked, my colleague wrote the judgment, Justice Sundaresh. We discussed existing law. We just said how things which should happen are not happening. Why what used to happen in district court or passing on the burden to the High Court is getting passed on to the Supreme Court. People are not wanting to take the call. And then long arguments take place, producing long judgments. And then the feeling is, well, oh, these long judgments may affect the prosecution, though the admitted legal position is a bail order doesn't affect the prosecution ultimately. So this takes its own time. And in that judgment itself, we had suggested that the government should explore a bail act, or I really don't know whether something happened out of it or not from the government point of view.
But if you could just outline for us some of the things that you had suggested, if there is to be a bail act, which then means that you don't have to re-decide things and constantly appeal things. The basic principles are laid out in the Bail Act, and everyone is told, from district courts to high courts to the Supreme Court, that, look, this is what the law is, this is what the Bail Act says, just follow it by and large. What would you put into an ideal Bail Act?
So it needs structuring, that's all. Look at the nature of offences. Look at the basic principle, why do you need to keep him under custody? Keeping a little bargain for the economic offences, but there also ultimately it should be, the investigation may require a little more time because of the nature of intricacies of the transaction. But it can't require years to investigate into the matter. So you have to come up with some time frame schemes within which you should decide. For example, another thing is we don't have a sentencing policy as such. There's a lot of discretion. Some discretion, of course, has to play with the judges. But the absence of a clear sentencing policy also creates a scenario where different results follow in different cases. These create uncertainty. If there is uncertainty, then the matter gets carried to a higher court more often. On the lighter side, I used to say, see, we don't have a Supreme Court of India. We have Supreme Courts of India. Every bench is a Supreme Court. It's not like the US Supreme Court, it sits in a bench of 9 judges together. So, and people are different, so some views will differ, which also creates its own dynamics in the whole situation. We take examples of more developed country. In the US court, the Supreme Court sits for about 100 cases in a year. In India, on a Monday or Friday, each bench of the Supreme Court has at least about 50 to 60 matters. 14 benches sit. So you have to look at the dynamics of what is happening in our system and the time frame which is required to read and produce results. It's not that the Supreme Court is interfering with a very large area. If you see some data which is available, Vidhi came up with this, that the interference level is less than 15%. Whether it's more, it should be more or less is a different matter. Despite that, the scrutiny area and the volumes become large, and what some of the current judges at times in informal discussions say, that the bail cases are one of the huge areas. Now let's take another category, nothing much to be done, but transfer matters. What are transfer matters? Largely in matrimonial matters where cases may be filed in different jurisdictions. Now, the court where it is filed may not have jurisdiction with the other district. So you are going to a different state. All these come to the Supreme Court. Some states they were being dealt with in chambers. Then they were said a single sitting will take place. Now they come before regular benches because they used to accumulate. So between the bail matters and these matters, it is cluttering the court's time. Each of them will require that couple of minutes. It's not majorly, but it will still require a couple of minutes. And the impression I was given was the greatest area, which we'll come to later, is the bail jurisdiction invocation in Supreme Court is also creating a huge backlog where every day the court has a large number of bail matters and every bench will have it on a Monday, Friday.
So isn't the solution to that for the Supreme Court as the ultimate court and the decider of the Constitution to more or less lay down what you said, that this is the principle which needs to be followed, and don't come to us if the matter can be decided on this? Like you, for example, laid down the law, literally, you laid down the law in one of the most famous cases that you heard, where you said somebody who is being, when you are to file a charge sheet, you don't need to arrest somebody. And that clarified matters for everybody. No one is doing that anymore. Similarly, if the principle is laid down that, okay, here are the one, two, three, four things to be kept in bail. If the person is not a flight risk, is not going to be tampering with the evidence, is cooperating, you don't need to arrest the person. Oh, these are the categories where you do need to arrest the person. If it's codified, it becomes simpler to do.
See, it's not codified, but the law is very well enunciated. It's an implementation. So let me say that what troubles the executive is also to some extent troubling the judiciary. The district court says, why should I take the burden? I grant bail, somebody will again come after me. Let the high court do it. This is how the high court burden increased. Now, with respect, because of sometimes some views in Supreme Court differing, the high court also says, okay, you go to the Supreme Court, so they'll take one. So there's an element of over caution which occurs in these matters. And then arguments go on, drag on for days together. I've never understood this. How can there be, we also have this phenomena of something being heard in part, then listed after 10 days, 15 days, then another after 2 months. You forget the arguments. Once a hearing starts, it must go day to day and finish off, and within a time-bound schedule. That's necessary. Then you start the next matter. So trying to hear a little bit of everything produces very little results. This is one of the, I would say, management issues which can be tackled, how to deal with it. If these many cases will come up, judges will continue to have this problem of how to deal with the cases.
Do you think that it's not more prudent? So I'm coming back to, again, your thesis of saying, let's prioritize the time of the Supreme Court because that time is precious. If certain principles could be laid down, you were telling me a little earlier that tax, for example, there are 30, 40 principles. If those could have a decision taken, then probably a lot of the cases which are pending in tax matters before the court, or negotiable instruments. There are lots of matters where if certain principles are quantified and laid out, then matters can be left to the lower courts. Is that what should be prioritized?
So, okay, there are two different aspects which I'll deal with it here. One is that these cases which are, say, the tax matters. So, okay, at some stage it was discussed with the administration, this was pre-COVID time, that how many principles of law are they going to be decided with? And it was same, some under 50. And they said a lot of money is stuck. Whether that money theoretically stuck, whether at all something will come out of it or not, is not known. But somehow those creation of benches, identifying those aspects, ultimately the COVID intervened and never took place. Negotiable instrument is a category by itself. See, apart from anything else, I have felt that there should be always a legislative impact study when a new legislation is brought in. It was never done in negotiable instruments cases. It has not been done largely thereafter. Whenever some new legislations come, I used to ask in court, has the legislative impact study being done? Have you looked at it? What does it mean? This litigation is expected to generate X number of cases. To decide X number of cases, we need Y number of judges more. That judge means you need the space where the judge will sit, you will need the personnel to assist him, you will need housing for him. So he doesn't come alone, he comes with a whole baggage with it. All that work has to be done. So another classic example was when Bihar prohibition was enforced, complaints came to Supreme Court on the judicial side that those cases are not being heard for a month on the bail. I remember discussing with the then Chief Justice, he said 16 out of the 23 judges are doing only bails, so some other will do something else because the cases are very large. Then somewhere the courts pushed. We said, okay, the first time offences, reduce it, do some other steps out of it, so that we are not left with it. So this is another problem, that when law is brought into picture, you must do a background of what litigation will be generated and what infrastructure and manpower you need to decide those cases.
That's true for litigation and for laws in general, but I know you've also, for example, hearing matters like just before you retired, the question of PMLA, and then there are other special, laws that come like UAPA and others, and people sometimes wonder as to what impact they have because that's a slightly different jurisprudence. People can stay in jail for a long time, burden of proof is reversed. Those have their own set of challenges, presumably.
Yes, they have their own set of challenges. That I did not get the privilege to ultimately take a call whether some aspects of this required to be reconsidered or not. Judgment is there. The debate was only before us as to whether it could be done or not, but as it transpired, we didn't get a chance. It's still, the issue is still pending. But there are some of the subsequent judgments which have, I think, watered down the effect of the earlier judgment, giving a little more leeway so that people are not unnecessarily kept behind bars. So I think some judicial work has been done to help ease that out situation. But see, example I gave of the Negotiable Instrument Act. Singularly, this category of cases is the largest pendency of criminal cases at the trial court. You are getting dates after 10 months on Negotiable Instrument Act. When you criminalized it, what was really a civil offense of bouncing of the check, did you envisage that so much of volume of litigation would arise? Then is this not a subject which has to be specifically dealt with and tackled and said, how can we see that these cases get out of the system? So man fights till the last court. When he is going to be convicted in the last court, he'll say, okay, I'll pay up now. But he has spent so much of time, energy of the system, that I personally felt, I used to put cost on them, that you have taken time of a judicial system, now you say you'll pay. So we have to look at a category and see how that category has to be dealt with. If some of the larger pending categories are dealt with, I think we can have a solution. Another example was, say, motor accidents claim cases, appeals. Not a very complicated issue. Law is settled everywhere. The largest single category of cases pending in both Punjab and Haryana and Madras High Court was MACT appeals. Now, why should that be happening? So we took it up in the Supreme Court. We tried to improve a system where the government develops a software which is available, which connects with the police, sees that compensation is given at the time due. Now, so you tackle, say, MACT appeals in a particular manner. You tackle negotiable instrument cases in a particular manner. So if you find solution to a couple of category of cases, which are high pendency cases, then you get rid of them at one go in this process.
That would, of course, be another very, very major way of taking things forward. Would there be any other big suggestions that you would like to make on how do you unclog the system and get it moving faster?
See, we have discussed most of these issues, I think. But I will say that a linkage of all of them, no singular aspect can cure the situation. So you have to have better management skill. Judges have to handle it in a slightly different manner, the cases. Lawyers have to learn to argue less and how to prepare a shorter synopsis. Government has to reduce its litigation. The consequence of cost, especially in commercial litigation, should be such that if somebody ultimately loses, he will wait. A lot of countries, the cost itself is a deterrent, so they don't go into litigation and resolve it. Government is now wanting to encourage mediation. I think it's I'm a great votary of mediation in many cases across the board. It's not only family, it's commercial cases and others, which need to be solved without going into litigation. Because if you resolve a case, often you resolve multiple cases arising from the same cause. For example, in matrimonial cases, I used to call them a bouquet of cases. The lawyers will file some half a dozen cases arising from one fundamental dispute. Similarly, in commercial
and
disputes,
sometimes criminalized matters which don't need criminalization.
This is happening in commercial cases also. So the growth of civil cases is not so large as the criminal cases. Why? The criminal jurisprudence is being utilized to create a criminal offense because they feel the civil case will not give a result for many more years. So try to pressurize the parties to settle. Ultimately, the objective is to, resolve the issue. Most countries resolve many matters through mediation or alternative dispute resolution. In US, I had an opportunity in exchange Justice Department programs to go and study the systems there. 97% cases are resolved through mediation, ADR, plea bargaining. 3% cases go to trial. In India,
97% go through mediation.
Yes. We studied the Californian system, which again has a very huge cases, which in 80s had a similar scenario, very large number of cases. Between costs, between ADR, between plea bargaining, they were able to work out a system where only 3% cases go to trial, under 3%. In India, the number would possibly be 99 point something more. They have a robust defense support system and a prosecution system. So systematic thinking is necessary. Unless we reduce the number of cases coming to court, reduce the number of tiers of scrutiny to court, and reduce the government's role in litigating, the ease of doing business on a commercial side will not be helpful. See, if you have an arbitration, let's say, supposed to finish matters, if the objections to the award, if the appeals to that take another 6-7 years, the very purpose of a quick arbitration goes.
You lose the arbitration, you go to
Yes.
court, what's the point?
And now we have a scenario where government has issued orders. They say that if the claim is less than 10 crores, then only go to mediation, arbitration. Higher cases, mediate or go to the civil court. Now, we are saying on one hand, there are commercial hubs which are coming up. Singapore has come up as a commercial hub. Bahrain is trying to do that. We have a potentiality of having a hub here. But if we are not willing to even go to arbitration, then how do we create an arbitration hub in this situation?
To solve some of these issues, I know the government is moving towards decriminalisation. Janvishwas, another bill has come removing frivolous laws. That presumably is a step in the right direction because it prevents people from using criminal laws to either harass people or to do rent seeking or to convert civil matters into criminal offences.
Yes. I think it's a small beginning, but it's a beginning of making civil disputes really be characterized as civil disputes. But those civil disputes then must see the end of the day quickly. See, at one stage, say, the rent tax clogged the thing. We changed the rent tax. The judiciary intervened to change the rent tax in Delhi. And today, that area of litigation has watered down. So it was a concerted effort administratively and judicially. The amended act actually never came into picture for decades together because of different power lobbies backing different sides. So the tenant lobby would not let it happen. But then judiciary took over some of these things and changed it. So each area, we have to, I think, identify the laws which are creating the maximum litigation, then see how that subject matter can be dealt with. As I said, one solution all is not possible. If we do that, then we can maybe tackle the bulk area of creation of work in certain ways, and that will also help in easing the situation.
Right, that's an absolutely fantastic blueprint, Justice Kaul, on how we can clean up the judicial and the legal system. But before I allow you to go, I just wanted to touch on one or two of really the landmark judgments that you've passed in you passed, and get your sense of it. The one on privacy, for example, and which was also used in the same-sex union matter. Do you think that those issues that you had once expressed about privacy are even more important now, given the rate at which digital is spreading, AI is coming, the risk of snooping perhaps going up? Are you more concerned than you were even then?
So when we debated the privacy issue, we knew that we were laying down the broad contours. That we did say that the nuances of it will play out as we go ahead. But the pace of technology change is very, very fast. And what is happening is the misuse of technology, which is a huge issue. Therefore, the privacy becomes one of the greatest casualties in this. So according to me, this is going to be very important if we want our lives to be our lives, that technology should not be permitted to invade into our lives. And corrective action in that behalf is certainly required.
Right. And perhaps one time where maybe there's a little bit of emotion from inside your heart that was expressed in a judgment. Was it in Jammu and Kashmir when you spoke about the Truth and Reconciliation Committee? Is that something which you still think would help heal some of the wounds?
See, on a personal note, my family went through the partition and when Pakistan was there. We shifted here. We were based in Kashmir and Lahore. It was Kashmir and Delhi then. Again, we saw this scenario occur in '89. See, the grievance of the community which was compelled to migrate from there was that nobody recognized our problem. And when army and other forces come in subsequently, there are bound to be some element of force which will be used because the army is meant to fight battles. It's not meant to control law and order. So there are different sects of aggrieved people. The objective that was, if you set up a Truth and Reconciliation Commission like they did in South Africa, you at least get out of the system. You get those people to be heard, to see what has happened to them. Recognize that something wrong has happened. You may not be able to give a judicial remedy to it, but acknowledge what has gone wrong and see to it that this kind of a thing is not repeated because you acknowledge the truth of what has happened. if you don't acknowledge the truth of what has happened, apart from whatever monetary or displacement which has occurred, or excesses which may have occurred, that lingering feeling would continue to be there.
Justice Kaul, it was such a pleasure and an honor to have you with us on the India Story. Let's hope that entire fantastic blueprint which you've laid out for legal and judicial reform, let's hope all of those steps are acted upon and we can actually get to speedy and therefore far more effective justice. Thank you so much.
Thank you, Mr. Chandra.
Thank you.